to meeting number 27 of the House of Commons Standing Committee on Finance. Pursuant to the motion adopted in committee on Thursday, February 17th, the committee is meeting to study the invocation of the Emergency Measures Act and related measures. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. So you're aware, the webcast will always show the person speaking rather than the entirety of the committee. Today's meeting is also taking place in the webinar format. Webinars are for public committee meetings and are available only to members, their staff, and witnesses. Members enter immediately as active participants. All functionalities for active participants remain the same. Staff will be non-active participants and can therefore only view the meeting in gallery view. I'd like to take this opportunity to remind all participants of this meeting that screenshots or taking photos of your screen is not permitted. Given the ongoing pandemic situation and in light of the recommendations from health authorities, as well as the directive of the Board of Internal Economy on October 19th, 2021, to remain healthy and safe, all those attending the meeting in person are to maintain a 2-meter physical distancing, must wear a non-medical mask when circulating in the room, and it is highly recommended that the mask be worn at all times, including when seated. Must maintain proper hand hygiene by using the provided hand sanitizer at the room entrance. As a chair, I'll be enforcing these measures for the duration of the meeting, and I thank members in advance for their cooperation. To ensure an orderly meeting, I'd like to outline a few rules to follow. Members and witnesses may speak in the official language of their choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen of either Floor, English, or French. If interpretation is lost, please inform me immediately and we will ensure interpretation is properly restored before resuming the proceedings. The raise hand feature at the bottom of the screen can be used at any time if you wish to speak or alert the chair. For members participating in person, proceed as you usually would when the whole committee is meeting in person in a committee room. Keep in mind the Board of Internal Economy's guidelines for mask use and health protocols. Before speaking, please wait until I recognize you by name. If you're on the video conference, please click on the microphone icon to unmute yourself. Those in the room, your microphone will be controlled as normal by the Proceedings and Verification Officer. When speaking, please speak slowly and clearly. When you're not speaking, your mic should be on mute. A reminder that all comments by members and witnesses should be addressed through the chair. With regard to a speaking list, the committee clerk and I will do the best we can to maintain a consolidated order of speaking for all members, whether they are participating virtually or in person. We're scheduled for 2 panels today, and we'll get our health break in between the panels during this meeting because it is of a longer duration. At this time, members, just before I go to the witnesses and introduce the witnesses, we do need to elect a first vice chair, and I am now going to look to the clerk to run us through that election.
Thank you, Mr. Chair. Pursuant to Standing Order 1062, the first vice chair must be a member of the official opposition. I am now prepared to receive motions for the first vice chair. Mr. McDonald.
Thank you, Chair. I'd like to nominate Mr. Albez for first vice chair, please.
It has been moved by Mr. McDonald that Mr. Albez be elected first vice chair. Are there any other motions? Is it the will of the committee to adopt the motion?
On division.
I will not take that seriously. I declare the motion carried and Mr. Albez duly elected first vice chair of the committee.
Congratulations, MP Albez.
Thank you, Mr. Chair. Thank you, colleagues.
Okay, thank you, and thank you, Clerk. Now, members, we will move to welcome our witnesses, and the witnesses for our first panel. They'll run from now 2:30 to 4 from the Canadian Bankers Association. We have Darren Hanna, Vice President of Finance, Risk, and Prudential Policy, and also with Darren Hanna is Angelina Mason, General Counsel and Vice President. In our second session, we have witnesses from the Royal Canadian Mounted Police, Michelle Arcand, Assistant Commissioner, Federal Policing Criminal Operations, and Superintendent Denis Boudoin, Director of Financial Crime. So now we will hear from our first witnesses for opening remarks from the Canadian Bankers Association.
Thank you. Good afternoon, and thank you for inviting the Canadian Bankers Association to appear today to participate in the committee's study of the invocation of the Emergencies Act and related measures. My name is Angelina Mason, and I am General Counsel and Vice President of the CBA. I am joined today by Darren Hanna, Vice President of Finance, Risk, and Prudential Policy with the CBA. The CBA is the voice of more than 60 domestic and foreign banks that help drive Canada's economic growth and prosperity. The CBA advocates for public policies that contribute to a sound, thriving banking system to ensure Canadians can succeed in their financial goals. On February 15, 2022, the Government of Canada invoked the Emergencies Act and made associated emergency measures regulations and an emergencies economic measures order. All financial service providers, including banks, covered by the order became legally obligated to implement the measures as stipulated by the government in the order. Banks took great care to fully understand their obligations and to ensure that they limited the order's applications to activities that fell squarely within its intended scope. The government indicated that the measures were intended to be temporary and focused only on a narrow group of individuals and entities involved in specific activities covered by the order. The vast majority of customers were not impacted by these measures. Upon receipt of information from the RCMP regarding individuals and entities engaged in conduct or activities prohibited under the regulations, banks acted in accordance with their legal requirements under the order. We can confirm that banks acted quickly to unfreeze accounts after the RCMP notified financial service providers that it believed that the individuals and entities previously identified were no longer engaged in conduct or activities prohibited under the regulations. While most of these accounts have been unfrozen, it is important to remember that some accounts are still frozen to comply with court orders or proceedings. On February 23, 2022, the government revoked the regulations and the order, and the associated legal obligations of banks and other financial service providers ceased. Thank you for your time, and I look forward to your questions.
Thank you, Ms. Mason. And I don't know if, is that the end of your remarks?
That is the end of my remarks.
Okay. Right, so we will move to the members' questions. In the first round of questions, it'll be a 6-minute round, meaning each party will have up to 6 minutes to ask questions. We will start with the Conservatives, and I have MP Chambers, you have the floor.
Thank you very much, Mr. Chair. Thank you to our witnesses today. As you can imagine, this is an important study for us. In the wake of the Emergencies Act, there was a considerable amount of uncertainty, so I'm hoping to help clear some of that up for Canadians and for members of this committee today. So just have a few questions, mostly around procedural issues, and let's see how far we get in the first 6 minutes. Have your members frozen bank accounts of individuals previously?
So previous to the Emergencies Act?
Correct.
Yeah, there are a couple of cases with that occurred, in part because of court order and in part because of a court proceeding. Okay,
thank you. And you've answered my second question, which was that followed a court order, typically.
Typically, yes.
Okay.
In one case, they actually applied to court, but yes, but they were both court initiated.
Okay, thank you. And so for clarity, this time there, outside of some extenuating circumstances or examples that you mentioned that are still under freezing, a court order was not presented to the banks in this case, is correct?
That's correct. It was a legal obligation by the order of under the Emergencies Act.
Okay, thank you. You mentioned about legal obligation. Do any of your members, are you aware of any of your members who decided to not freeze a bank account after having been presented evidence or information from the RCMP?
I'm not aware of that, no.
Okay. Would you be able to maybe check and confirm that answer with your members and provide that at future date?
Sure. If there
Okay.
was an individual circumstance of that nature, I'd be happy to.
Okay, thank you. And that's important, just for clarity. That's important because, you know, we have been told, the Canadians have been told, this committee has been told, the general public has been told that the decision to freeze a bank account rested solely with the financial institutions themselves. Would you feel that that's an appropriate characterization of the procedure?
I would say we acted primarily on information provided by the RCMP that was then validated through looking at the bank records.
Okay. Just to clarify that point particular, if the RCMP provides information about an individual that is a banked individual at one of your members, the extent to which you followed through on that was basically if that individual did have accounts, those accounts were affected and that individual is affected, right? I'm just trying to understand how much investigation or discussion with the RCMP went on, or was it, oh, here's the name, we have the name, and we will implement the freezing?
The name was provided along with details of the circumstance, and then the banks would look at their particular records and they could validate whether there was activity that was suggestive of those circumstances that were described.
Okay, thank you. Once an account is frozen and eventually unfrozen, are there any permanent markers or indications on a client's file that would indicate that they have had their accounts previously frozen?
There would be something in the file indicating that a freeze had taken place, but how that was, if what you're asking is how that impacts the relationship, that would depend on the particular risk scenario of any bank. There wouldn't be a blanket approach.
Okay, and do you anticipate banks reviewing the relationships with these individuals on an ongoing basis in terms of the risk relationship?
I would anticipate that they've probably already done that, and if anyone has any concerns with the impact on their relationship with their financial institution, they should contact their financial institution.
Okay, thank you. Have you been given any guidance or instruction from the RCMP or any other government official thinking about the Privacy Commissioner about how long you are to keep records that either generated by your institution or passed to you from the RCMP about individuals?
We have not received that type of guidance. There are obligations under privacy legislation to only hold information for the purpose for which it was provided as long as necessary.
Okay, thank you. In exchange for your carrying out of your obligations, what assurances or protections were financial institutions given by the government?
One was we did receive verbal guidance from the government on the scope of the legislation and how it would apply, so that we could ensure that it was implemented within the intended narrow scope. And there is also immunity provided under the order itself. Okay,
so as I understand it, you could not be sued or held responsible for any mistake in applying the rule. Thank you. So final question would be, prior to February 14th or say the 15th, did your members have any conversations or discussions with the government or the RCMP prior to the Emergencies Act coming into force?
Several of our members did have discussions with finance. We were given a heads up that this was coming, but we did not have the specific details. We received the regulations at the same time as the general public.
Thank you very much, Mr. Chair. I believe that's my time. Thank you for your willingness to answer the questions.
Thank you, MP Chambers. We are moving to the Liberals. MP McDonald, you have the floor for 6 minutes.
Thank you, Chair, and thank you to the guests here today. And I just want to say, all through COVID-19 and leading up to obviously what we're talking about today, but the collaboration with the big banks has been unprecedented in my time as I can ever remember. So I want to thank you for that, because I think rolling out those programs during COVID-19 was extremely important, and your help was appreciated. It's been said that the existing laws didn't allow the federal government to follow the money regarding illegal blockades and occupations, particularly involving crowdfunding platforms and payment service providers. Do you agree with that assessment, that the existing laws maybe were not sufficient in targeting the financing that was sustaining the illegal activity?
Insofar as the fact that they weren't covered by FINTRACT, I would have to agree with that.
And do you believe there are gaps that we, basically need to fill in our current laws and regulations regarding funds being used for illegal activity? So is there, I guess, what have we learned that you can provide us in detail relevant to going forward? Because I'm assuming with crowdfunding and these types of resources, this will not be the last we see of this type of activity.
Right. So I can't speak to the Emergencies Act itself, but when you talk about reporting, yes, that it does make sense. If you look at it when we deal with our obligations on players.
Okay. And previous question relevant to you freezing other accounts or the investigation of many accounts. How many of those accounts are actually still frozen at the present time?
I don't have the exact number of those that are still frozen. Any ones that are remaining that are frozen are because of the orders, the court orders and the provincial orders. All the accounts that were frozen as a result of the Emergency Act that weren't subject to those orders already are unfrozen.
Okay, so there was one Supreme Court of Ontario, I think, a judge froze bank accounts relative to that. So did you guys play any part of that role?
We did not.
Okay. If individuals disputed a decision to freeze their bank accounts, was there a mechanism in place for that? That there was almost not a hearing, but a red flag to say that this might be a mistake, or is this a recourse or something to that effect?
If someone had a concern, they would contact their financial institution. Where the financial institution was acting upon the information provided by the RCMP, then the logical step would be for them to contact the RCMP directly.
Okay. Were there any bank accounts that were determined to be frozen in error that you're aware of?
Not that we are aware of.
And how did the banks, in conjunction with the RCMP, and you mentioned this a little bit maybe in your preamble, possibly determine if one was sustaining an organized illegal activity? What's the red flag that goes up besides the obvious, maybe a large sum of money being deposited into an account? But is there other things that you look for when you're trying to make a decision whether or not that this may be of a fraudulent situation?
So in the case of the persons identified by the RCMP, we could actually look at the specific transactions. If what you're asking about is the other duties under the order, which talked about independent determinations by banks, that's a very different scenario. So if you're talking about the names that are given, which is again what the banks primarily relied on, then you can look at their specific activities. Otherwise, what banks relied on was on their risk-based approach, which is basically, they monitor in a general fashion for unusual activity, but that's a pretty high threat. Like there's a threshold to be caught, to be found to be unusual. And then it would then looked at in the lens of obviously the activities that were happening within Ottawa.
Right. And how much time do I have, Chair?
You have a minute and a half.
Okay. Just on the other side, basically what you're, or what I want to ask is, what changes do we need to make? You've talked about the process via the RCMP to the bank. Like, what is there anything that the big banks have learned in all this going forward, and how do they apply it to further situations relevant to the one we're in today?
Again, this has never been invoked before. So there were some, in real time learnings, including having clarity upfront as to the scope, which we were able to get. I think that was in large part attributed to the speed with which the act was invoked, but it was good to know up front, for example, that no activity prior to the date of the order applied. It was also helpful to know that once the accounts were frozen, there wasn't a forfeiture, and then once they were unfrozen, it was just a release of the accounts. So it's those kind of details that typically you would see in sanctions and other legislation that have been experienced more.
Thank you.
Okay, thank you.
And thank you, MP McDonald. Yeah, that was great. Right on time. We are moving to the block, and MP Sainte-Marie for 6 minutes.
Oui.
Yes. Good afternoon to Mr. Hanna and Ms. Mason. Thank you for being with us today. That's very much appreciated. If we correctly understand, the RCMP passed on to the financial institutions and banks a list of individuals and asked for their accounts to be frozen. When we read the order allowed the banks and financial institutions to freeze the accounts of people who were present or who were funding the occupation in Ottawa. According to you, do you believe that your members just froze the accounts of people who were on the list provided by the RCMP, or did they freeze the accounts of individuals who were not on the list provided by the RCMP?
Thank you for the question. First, I would like to clarify, it was not a case of allowing to freeze. It was actually a legal duty to freeze. And that's why we were very concerned, given that this was a legal duty, to ensure that it was applied in the very narrow scope of which it was intended. And yes, in addition to freezing the accounts on those names, there are some situations where accounts were frozen, again, based on the risk-based approach of identifying situations that were suggestive of participation in the activities that were covered by the order.
Okay, merci.
Thank you. That's very useful in terms of information. So on the one hand, the banks had to freeze the accounts of people who were on the list provided by the RCMP, but also under the order as drafted, the banks had to freeze the accounts of individuals who seem to be participating or financing the events in Ottawa, but who were not on the list of the RCMP. As the order, it has been constructed and drafted in a rather vague way. I think it's then difficult to enforce this, and there are not many details in the order. So I'd like to come back to a question that was put by my colleague, Mr. Chambers, and ask whether the Finance Department or another authority or the government or the RCMP provided you in writing with clearer instructions about the way in which to proceed. Because from what I've understood, they did not provide written direction, but it was verbal direction. Was that indeed the case?
So there was no published guidance as you would normally have for regulations, but that would typically be because, like I said, I attribute to the timing, because typically regulations would be published, you'd have a chance to look at them, ask questions, guidance would be developed, and then everything would come into force at once. But in this case, they were in force all at once. And so that's why we had to rely on briefings from finance to make sure we had absolute clarity on implementation.
So from my point of view, it's very difficult to have clear rules when they're not written down. What guidance were you given about joint accounts? If a person who was covered had a joint account with someone who was not actually covered with what was happening in Ottawa, what happened in terms of rental, payment of electricity, and also child support payments? Were you given indications for those specific cases?
So typically when an account is frozen, regardless of whether it's joint, it freezes the entire account. We did raise with finance what you would call so there weren't any exceptions in the order itself. So we did raise with finance what you would call humanitarian exceptions of the nature that you've spoken about. It was under consideration by finance, but then became a moot point quite quickly because they had revoked the order.
Okay.
Okay, thank you. That's very enlightening. So in the order, the government did not go into the details, as you've said, in terms of humanitarian exceptions. For example, a father who has to pay child support to his ex-spouse for children, but as he was protesting in Ottawa, according to the government order, if we freeze his account, it would be the child and the ex-spouse who would bear the costs of that decision, basically, because I would say there were details that were missed out in terms of the detailed execution of the order. I really find that really unacceptable. Sorry, for me, that really poses a serious problem. Now, in terms of your members, did they have the impression that they were having to play the police? They didn't need to limit themselves to the list provided by the RCMP, but they had to carry out risk assessments themselves to see whether people were actually protesting in Ottawa or possibly financing part of the protests in Ottawa. So did your members therefore have the impression that they were having to play the police?
No, in that case, they were having to identify, again, applying a risk-based approach, having to identify the specific activity, and then we would share that that information with the RCMP.
OK. OK. Donc,
Okay, so it was up to the banks to actually monitor individuals. I have many questions and time is ticking away. Chair, I say that my time is up, so I'll come back on the next round. Thank you very much again for your answers.
Merci, MP Samari.
Thank you very much, MP Samari.
P, and we have MP Blakey up for 6 minutes.
Thank you very much, and thank you to our witness for being here today. You'd said earlier that financial institutions had a duty to freeze the accounts of people who were either participating in illegal activities connected to the demonstration or who were funding illegal activities connected to the demonstration. And you've the RCMP furnished banks with evidence to the effect of whether or not certain individuals were in fact doing those things. Were there other sources of information for banks that they accepted or that they sought out themselves on the basis of which they did or would freeze any accounts? Or was it understood that only names submitted by the RCMP for this purpose would result in actionable account freezes?
So just to clarify, we primarily relied on the names provided by the RCMP, but there were obligations under the order separate from that that required banks to make their own determinations. We did not rely on external information. I know there's been suggestions of leaked donor lists, et cetera. We did not rely on that information at all. What banks were obligated to do, though, was apply their normal risk-based approach in monitoring their accounts as they would do for money laundering or what have you. And if something then was flagged that was suggestive, again, looking through the eyes of the activities in Ottawa, then there would be, again, an obligation to freeze.
So were there accounts of individuals frozen that did not appear on a list of names submitted to banks by the RCMP?
Yes.
Okay. And do you have a sense of the quantity of those names?
There would be a small number. I would say, if you look at again, we're in the customer business, so we wanted to make sure that our obligations here were limited and not in any way incorrectly going to the vast majority of our customers. So if you look at based on the numbers from the RCMP, that was 180 accounts. That's 180 accounts compared to just with our largest 6 domestic banks, over 60 million customers.
Okay, and I think we've heard in other testimony that at least up to the point we had heard the testimony that a total of something like 206 or thereabouts accounts had been frozen in total.
Right, but that would include other financial institutions, not just banks.
Right. Okay. So what would be the other kinds of information, or where would banks access that other information that feeds into their normal risk assessment? What kinds
Again,
of information?
it would be unusual activity. You know, it could be everything from a large deposits, which is, you know, could happen where someone appears to be using their personal deposit account as a fundraising mechanism. But like I said, there would have to be a threshold applied. It's not looking into minutia.
You had mentioned earlier also that accounts have been frozen under other authorities, like certain court orders. When accounts are frozen, are people notified under what authority the account has been frozen?
So in this case, the order did not address notification. So like other court orders, it was up to the bank's usual processes as how they wanted to deal with it. So in some cases, some clients were notified after the fact. In other cases, they weren't.
Okay. So at the very least, it was administratively possible for banks to be able to disclose to their clients that their accounts have been frozen under the authority of the Emergencies Act.
Yes, insofar it didn't prohibit it.
Okay. And if the government had added that as a criterion or as a requirement of the legislation, that's something that your members would have been able to comply with?
Yes, if it was a legal obligation, we would have to comply with it.
Okay. And is that something that you think, this is perhaps asking for a little bit of speculation from you, but I mean, do you think that that's something from the point of view of banks' clients that would have been useful for them to know that their account freeze had happened under the authority of the Emergencies Act? Or that if they wanted to pursue remedies against the government, for instance, if they feel that it was inappropriate, even under the act, for that freezing to happen, that it would be useful documentation for them to have?
So just to clarify, I just want to distinguish notice versus information. So even if a bank didn't notify their client, if a client contacted their bank and asked, why was my account frozen? A bank would tell them.
Okay, and that's true today. So if someone had their account frozen and they're not sure why, they call their bank and they ask the question, and the bank will give them the answer.
Correct.
Under what authority that account was frozen. Okay.
Yes.
Thank you very much. Do you think, because, and I think it was mentioned earlier, I mean, obviously this was the first time ever that this particular act has been used, and that we've had an emergency declared under this act. Do you think if it happens again and similar financial measures are put in place, that it would make sense for government to require notification to clients that their accounts have been frozen as a result of the Emergencies Act?
And a short answer, please.
Sure, that's a policy point for finance, which we would need to consult on.
Okay, thank you. And that's the time for our first round. Thank you, MP Blakey. We are moving into our second round, members. In this round, we're starting with the Conservatives, and we have MP Lawrence up for 5 minutes.
Thank you very much. Can the chair hear me all right? Yes, okay, perfect. I just want to sort of go through the process. So the Emergencies Act is invoked, Ms. Mason, and then your members are contacted presumably by the Finance Department and told how the process would work. Is that correct? Is that how it went down?
We were given a heads up that it was coming. We weren't given the details of the specific regulations until they were published.
Okay, and then they are published, and then the RCMP will give you briefs that say that individuals that contain evidence may have been involved in the illegal protest movement, and then you were to act based on your legal opinion. For each one of the briefs provided, did your members have their own independent legal advice, or did they just do what the RCMP suggests that they do?
Again, it was the RCMP provided the names, and then the bank looked at those names compared to their records and the activities in their records to validate if the names made sense.
And did your members freeze every single account that was provided evidence by the RCMP?
Again, I'd have to get back to you on that as to whether or not there were any accounts that members looked at and said, you know,
Yeah.
No. Right.
Based on the evidence of what I've heard the last ceremonies, committees, I think you can say that you had the autonomy to say no, but I don't think you did. And in fact, the RCMP the RCMP providing evidence was tantamount to their bank accounts being frozen. There were very few exceptions on that. Would you agree with that?
I would say it was very challenging to dispute what the RCMP had provided us.
Yeah. So basically, even though you had in legal terms autonomy to say no, you didn't. Your members didn't, I should say, and that every account that the RCMP wanted frozen got frozen. That's generally correct, right? Like to the 90th percentile or so.
I would have to validate the point, but my understanding is most of them were frozen.
Okay. And your members are, of course, going to do a legal calculation on this. And so could you just tell me if, in fact, the bank account didn't freeze account, they could face significant consequences. Is that correct?
I'm sorry, I didn't hear that question.
Sorry. So if the RCMP provided material that the individual should have had their account frozen, the bank chose not to freeze them, your member chose not to freeze them, they could face significant consequences, couldn't they?
Well, there would be concern about not meeting our legal obligation.
Exactly. Whereas on the other side of that, if they froze an account incorrectly, because of the way the proclamation was drafted, there would be no consequences to your members, right?
Okay, but to clarify on that point, the members were not wanting to freeze any accounts they didn't have to, given obviously we're in the customer business. So we don't want to be using that, we don't want to be invoking that obligation in a way that isn't prudent.
For sure. And I know that your members would want to do the best for their clients, but just looking at this in a strict legal scoreboard, if in fact they illegitimately froze a bank account, they would face zero legal consequences. It's clear from the legislation.
Again, I would remind you that of our trust that our customers place in us to ensure that we fulfill our obligations appropriately.
Right. So there was zero consequences if they froze one incorrectly, but if they didn't freeze a bank account, there were serious consequences. So if in fact you were doing your risk management, which what banks do very, very well, there would have to be a disposition or a bias towards freezing a bank account as opposed to not freezing a bank account.
I don't think that's actually the way the risk assessment was done. I think it was trying to respect the spirit of what the intent was and ensuring that we were only freezing accounts on what we understood to be individuals or entities that were engaged in the illegal activities.
Yeah, but I mean, it's clear that there is a legal bias towards freezing than not freezing, just looking at the legal side of things. Just with respect to the information provided by the RCMP to your members, could you provide some explanation as to what was in this bias? For example, with the individual's location, their financial wherewithal, their gender, their race, whether they were Indigenous be included?
I don't feel comfortable explaining what was provided to us by the RCMP. I think that's better a question for them.
Okay, but you received the information, right? Oh, sorry, Mr. Chair, my apologies. Go ahead.
Oh, we've just gotten to your time. Okay, but thank you, MP Lawrence. I'm sure you'll have another round where you have an opportunity. We are moving to the Liberals, and it's MP Zarowitz up for 5 minutes.
Thank you so much, Ms. Mason. You're doing a wonderful job. Thank you so much for being here today. And thanks for all the questions. It sounds like we're almost like, in a court, but you're doing great. We're very curious and you're doing a great job. So thank you. I just want to start off by just clarifying, just because I want to make sure it's clear in my head, what were the banks able to do with the Emergencies Act that they weren't able to do before? And I think from what I've heard from what you've said is that you were able to freeze accounts without a court order. So that's one thing I've heard. And also it allowed the banks also independently to move forward and also do a bit of a review for any type of suspicious activity that might actually provide enough justification under the sort of like mandate of what we are asking the banks and financial institutions to do to be able to freeze accounts. Do I have that right?
Partially.
Okay.
So we are already able to look for suspicious activity. That's part of our monitoring that we do for anti-money laundering under their obligations under the Proceeds of Crime legislation. It then invoked an obligation to freeze if we found something that was in, again, that limited scope of the activities within Ottawa. So it was actually creating an obligation to freeze, which is different than we normally have in the AML world.
Okay, thank you. Thanks for that clarification. It's very helpful. We had, in one of our speeches, our Deputy Prime Minister and Minister of Finance said this is about following the money. It's about stopping the financing of these illegal blockades. And today we're serving notice. If your bank is being used in these protests, your corporate accounts will be frozen. And you may not be able to answer this question, but when the RCMP actually asked you or provided information to the banks, did they actually say to you, this is because this is a corporate trucking company, or did they give you the reasons, or they just gave you the information and your job was just to follow through once you've validated things on your end?
They gave a high-level description of what they thought the activities were.
Okay, thank you. And the other question I have is, so when I go through the four things that is under the Emergency Economic Measures Order, the third is the government directs the Canadian financial institutions to review their relationships with anyone involved in the illegal blockades and report the assets and related transactions to the RCMP or CSIS. When you said that part of what you had done under this act was to do a review for suspicious activity, would that be encapsulated into that third, or was there more that you actually did?
No, that was it. What I was trying to distinguish was when you're given a list of specific names, then you would look at those activities of those specific names. When you're not relying on that, but relying on your normal risk-based approach, then it's only that which is the threshold of unusual that catches your eye, and then you look at it in that context.
Okay, perfect. And then fourth, the order also provides federal, provincial, territorial government institutions with new authority to share relevant information with banks and other financial service providers if the information will help put a stop to the funding of illegal blockades and illegal activities. So other than the RCMP, were there any other institutions that provided more information to banks that allowed you to sort of do the freezing of accounts, or that led to more enforcement under the Emergencies Act?
I am not aware of that occurring, but can check and come back.
Okay, thank you. There were stories that we heard that bank accounts were frozen, individual bank accounts were frozen for just donating or purchasing merchandise associated with the blockades. And the RCMP put out a statement which read, "At no time did they provide a list of donors to financial institutions." Can you clarify when these measures were implemented and whether or not any of your members applied them retroactively?
Members did not apply them retroactively. The order came into force February 15th and expired February 23rd. There's been a fair bit of misinformation out there, and I would just ask that when stories like that come up, that they actually be validated, because as I said, they would be inconsistent with how our practices are applied.
And
thank you.
Is that enough?
Yeah,
well, thank you so much,
time.
Ms. Mason. Thank you so much.
Thank you.
Thank you, MP Zarowitz. We are moving to the block, and MP Sainte-Marie for 2.5 minutes, please.
Oui, merci.
Thank you, Mr. Chair. Our role as a parliamentarian is to assess whether the government absolutely had to enact the Emergencies Act in order to intervene. It's the ultimate recourse act. When we look at regular laws such as the Criminal Code, the Anti-Money Laundering and Anti-Terrorist Financing Act, we can see that these ordinary acts stop financial fraud and money laundering of ill-gotten gains or the financing of criminal activities. So I've got two questions to put here. When you froze the accounts, did your members do this under the application of the ordinary legislation that I've just mentioned, or under the Emergencies Act, and which allowed the emergency measures order to do something more than the ordinary laws would have allowed your members to do? Thank you.
Okay, sure, happy to answer that question. And again, in the cases of the orders, so the court orders, those were again legal requirements, and those were based on court proceedings. In the case of the Emergencies Act, there was a legal obligation to freeze, which otherwise would not be there.
And when you suspected that there was financing of criminal activity in normal circumstances, the banks will freeze the accounts when they have that suspicion? Is that the case?
It depends on the particular fact circumstances of whether it's something that you report versus, and then you would, for example, report to the RCMP, and they perhaps would then get production orders and take it from there. So it is not your typical situation.
Okay, so what you're telling me is that this is not a typical situation for banks to actually freeze an account when we suspect that there's a funding of a criminal activity. That's what you've just stated.
Question on how you handle it, you can let the RCMP know, and then they would take particular measures. In this case, it was a legal obligation to freeze. There was no discretion on how a bank could act.
Okay.
I'll come back with other questions later. Thank you.
Thank you, MP Samari. And we are moving to the NDP and MP Blakey for 2.5 minutes.
So thank you again, Ms. Mason. You'd said in your earlier comments that the government didn't address the question of notification, how to notify folks that their accounts had been frozen and under what authority they had been frozen. In other cases, under other laws where accounts are frozen, is it typical that a court order would address the question of notification?
It's quite often they don't. And so again, the members are in a position to apply their usual processes. For example, if someone hasn't paid child support and, they've get their account seized, a member may decide they don't need to be notified of that. They know they haven't paid child support for many years. So, it's a question of what the particular process, whereas others may choose a different approach.
Okay. In the question of joint accounts that had come up earlier, you had said that was something that was being addressed as a potential problem, and there was some discussion about how it might be solved. Do you think that it would be useful to carry on those discussions, and in future, if government does ever use provisions like this again, for there to be some more clear direction at the outset as to how difficult cases like those would be managed?
Yeah, again, finance was considering that, and it became a moot point, but my guess is they would probably include that themselves.
Right. Do you think it would be useful to your members in a future event where something similar were to happen, to have more direction up front from government as to how they'd like those more complicated scenarios to be handled?
Yeah, that would be helpful.
Okay. Thank you very much. That's good for this round, Mr. Chair.
Okay, well, thank you, MP Blakey. And so we're moving to the Conservatives, and MP Fast, you have the floor for 5 minutes.
Thank you very much to our two witnesses. I appreciate you being here. Two questions. First of all, a follow-up on Ms. Derowitz's question. You mentioned that donations in themselves would not trigger an assessment as to whether that donation falls under the order that the government triggered, correct?
I said that I was trying to establish the actual application of outside of the names that were provided by the RCMP. A small donation wouldn't have been caught by our normal risk-based approach. So what I was trying to emphasize is that highly unlikely. And also I wanted to clarify that we did not rely on external information, including leaked donor lists.
Okay, understood. What about a large donation? Whether directly to the convoy or through a crowdfunding platform?
Sure. If conducted during the time that the order was invoked, it would raise that legal obligation.
And what's the threshold?
again, there's not like a specific dollar threshold. You'd be seeing, is there some sort of unusual activity going on?
Unusual activity. If someone with a bank account of $10,000 decided to give $3,000, would that be an unusual activity in your mind?
Again, I couldn't speak for the specific circumstance of that monitoring, what would trigger it. It may not, depending on what their normal account activity is like.
All right. Another question. In the days following the invocation of the Emergencies Act and information about the freezing of accounts became more public, did the banks notice any increase in withdrawal activity? And I was one of those who actually contacted the CBA to find out, but I'd love to hear it from you. Was there an increase in withdrawal activity in the days following the triggering of the Emergencies Act?
There are anecdotal stories, not anything of significance, but in part, again, misinformation where people thought if their account was with a bank as opposed to a credit union, that somehow that would make a difference. And so there was some information and education there that the Emergencies Act applied regardless of which type of financial institution was engaged, but there has not been anything of concern. It's like, again, these anecdotal stories.
Okay, so you refer to anecdotal stories, but as a matter of fact, are you saying that in fact withdrawal activity did not increase measurably?
That's correct.
All right. Did you take any steps, or did your industry take any steps to assuage account holders across Canada that in fact there wasn't a rush on money at the banks and that everything was going to be fine?
I don't recall making, I mean, we typically don't respond to misinformation about those types of things, but I would turn to my colleague, Darren. Do you know if there was any proactive comments made?
I wouldn't say proactive comments. I mean, at the end of the day, to Ms. Mason's point a moment ago, we didn't really see material change. So look, if people had concerns, certainly each bank would respond to those concerns, but that would be on a customer by customer basis.
Okay. You mentioned, Ms. Mason, that the government, you consulted with the government on the way forward, the scope of the legislation, how the government expected it to be implemented. Did you actually trust the government fully to provide you with information that was factually and legally correct? Or did you seek out your own legal opinions on how the order and the Emergencies Act should and could be applied?
I would say that the guidance being provided by the government was well within the specific language in the order itself. So obviously all of our banks have in-house counsel. I myself am counsel. So we all would have looked at the order itself and seen what the scope of those obligations were. And so when the government advised of their intent, which made it quite targeted, that was considered to be reassuring.
So did you feel that you had any discretion to say yes or no?
Sorry, that was the time, MP.
All right.
Yeah, but thank you. And I'm sure you'll have an opportunity in another round. We are moving to the Liberals and MP Chattel for 5 minutes.
Thank you, Chair, and thank you, Mrs. Mason and Mr. Hannan for being with us today. And also thank you for your hard work and having in Canada such a healthy financial institutions. So just a point of clarification from a concern raised by MP Lawrence. I just want to make sure I'm clear on that point. There was immunity for action that were taken by financial institution in good faith, but there would be legal consequences for anyone using this legal obligation in bad faith.
That is correct.
Thank you. The proceed of crime legislation requires banks and financial institutions to report suspicious transaction. Mrs. Mason or Mr. Annan, could you tell us exactly what is a suspicious transaction?
A suspicious transaction is a transaction where, if you look upon the facts, is suggestive that there might be money laundering occurring.
And would that suspicious transaction concept by which you have to report change with the Emergency Act?
No.
Could you explain a little bit the reporting process under existing rules that you have to do to FINTRAC and to the RCMP and your interaction with those organizations?
Sure. So when we report to FINTRAC, there's two types of reporting. One is suspicious transactions, where you have transactions that could have that are suggestive that there might be some money laundering that's occurring. The other kind is called threshold reporting, where we're required to file all types of transactions, regardless of whether they're suspicious or not. For example, large dollar cash withdrawals, large EFT transfers, and those are called threshold reportings.
And so you explained that it has changed, that you had to freeze accounts, which under current rule, you don't have this legal obligation once you have found, for example, a suspicious transaction. But the Emergency Act was not just limited to money laundering. It was covering illegal activities such as the blockage and as defined within the Emergency Act. So that we could see as expanding, because current rule do not require even you to report if you find that there's suspicious transaction, that they're not necessarily money laundering or terrorist financing, but they are used to finance illegal activities in Canada. Correct?
Correct, in the sense that if we were concerned that someone was using an account for illegal activity, we may raise that with the RCMP. In this case, we were actually required to validate against the list provided by the RCMP, and also take specific measures to look for apply a risk-based approach to look for this specific activity.
And a crowdfunding platform was an obvious case where it escaped actually the scope of the proceed of crime legislation. They don't have reporting activity, so it's a way to, indirect way to finance illegal activities. To your knowledge, Mrs. Mason, is there any additional platform that are left out of the current reporting that should be covered, because that's a way criminal or money laundering or financing of illicit activities taking place today?
Not to my knowledge. I know I could take that away. I know as part of our advocacy within the AML space, we have supported the expansion of reporting entities to address gaps, including cryptocurrency, which was recently included. So I can take that away and see if there's any additional ones that we as an industry has supported. But yes, you are right. There are gaps that have been closed.
Thank you. I would really appreciate you following up on those gaps. I'm very interested in that. Thank you.
And thank you, MP Chattel. That is the end of our second round, members. We're moving into our third round, and just looking at the time, this will be our last round of questions from members to our witnesses. So we're starting with the Conservatives, and I have MP Albus up for 5 minutes.
Thank you, Mr. Chair, and thank you to all of our witnesses for coming and bringing some light from your perspectives on the study. I'm going to start with Ms. Mason. Ms. Mason, I just wanted to ask you, typically when we're dealing with money laundering or sanctions or whatnot, obviously a court order would be necessary. Do banks find it helpful that a court order may limit some of the that it may give you a little more comfort when you're placing and freezing or seizing accounts?
Well, like a court order, we are legally obligated to do it. The benefit of the court orders, we're not asked to validate anything.
So again, the court identifies where perhaps in this case the RCMP have a legitimate case, or maybe where they think, okay, you're just fishing for things. In this case, so you're just given names and we're asked to start freezing assets. Is that correct?
Well, again, we were given names and asked to validate against them.
Yeah.
It isn't your typical process. I agree with you. And in the case of sanctions, there's actually prescribed lists that have already been reviewed.
Can you maybe explain just that point? Because many people are watching right now and seeing what's happening in Ukraine. And I think it's important that people understand that there's a usual process that has to go through. Can you just elaborate on that?
Sure. In the case of sanctions, we're very familiar we have a long history of implementing economic sanctions within Canada. It's a known process. And so when individuals and entities are named and particular actions are restricted, we've been able to implement those in the past. The challenge, some of the complexity of the Emergencies Act was because it had never been invoked before. We had a number of questions about various things on how you implement.
So when the RCMP when the government wants to put in place a sanction, they do have to go through a court process so that you can have lawful authority. Is that not the case?
Sorry, it's not a court process. I believe when the sanctions are invoked, it is a government process.
Okay. So it's a separate process than that. Okay. Thank you for that. And so the next question I would just simply ask is that when the courts do in the usual process, when the court's limited, it gives you a little bit more comfort, though, when your clients have to then move forward. Do they have an obligation to then tell the client of the bank that their assets have been frozen under an order?
Not necessarily. Orders may not provide it at all, and in some cases, in some cases, orders may not specifically address notice. In other cases, orders were actually required to keep confidential. So it really does depend on the specific order.
Okay. No further questions. Thank you, Mr. Chair.
Thank you, MP Albus. And we are moving to the Liberals, MP Maloney, for 5 minutes.
Thank you, Chair, for the opportunity and letting me participate today. Ms. Mason, thank you. This has been very informative. Let's go back to what you said at the beginning. You said you would act on information from the RCMP and then you would clarify it through the bank records. A moment ago, in response to Mr. Albus, you had a discussion about the validation component to this. Can you just take us through the validation aspect of this? Because that's obviously very important to the discussion.
Well, it would depend on each particular institution and what was in their records. But let's say, for example, they said this individual has been funding events in Ottawa, and then you can see, and again, it's because we were asked to look at these specific individuals that we then would look specifically into their transactions or accounts, and you could then validate, well, yes, those transactions were occurring, and they're of the nature that were described to us, which again was very different than and separate from how we were managing people who weren't on the list.
Thank you. So am I accurate then in saying that every request you received from the RCMP was subject to this validation process?
Correct.
Okay, thank you. Now, what would the turnaround time typically have been during that week or 9 days from the, and to be clear, the request was coming from the RCMP, not from the government, right?
Right. So the lists came from the RCMP. My understanding is the government did not have line of sight into those lists, right, but the obviously the guidance on how to implement was coming from the government.
Okay, thank you. And so what would once you received a request from the RCMP, take us through how long it would take to implement the freeze?
We were implementing quite quickly. We had staff ready, and it would be within 24 hours.
But built into that request time was some back and forth with the RCMP if you had any questions or there was any uncertainties?
That's correct.
Okay. And the RCMP, I mean, they didn't come into this situation the day the Emergencies Act was invoked, they had in fact been dealing with these actors out in Ottawa who were involved in this for some time prior to that. So they came to this with much more background. So this wasn't something new to them. Is that fair to say?
That's correct, which is why I say we primarily relied upon them, that they were coming to us with a rather limited but definitive list.
Okay, thank you. And through your experience and from talking to your member organizations, would everybody agree that the RCMP was willing to work with feedback received from financial institutions to make sure that the requests were implemented properly?
Yes.
Okay, thank you. Now, I think you said earlier that there was 180 accounts that had been frozen through the banks. Is that correct?
That's correct.
And do you have data on to how many of those accounts were corporate or businesses as opposed to individuals?
I could get a breakdown of it, but there were at least a couple of corporates. I'm working from memory now.
But most of them, I would suspect, would have been businesses and corporations or people, larger entities that were involved in the protests. Is that fair to say?
No, I would say that it was a balance. There were a number of individuals.
Okay, thank you. And I think you've already addressed this earlier in response to Ms. Zarowitz's question and maybe Mr. Lawrence, but this notion out there about making sure information is correct. There's stories been circulating about little old ladies who had their bank accounts frozen and they only had $50 in the bank account. The bank would use the validation process to make sure something like that didn't happen, I'm assuming?
That would not even hit the radar. That's why it wouldn't happen. So, and if anyone had any question, they should contact their bank, because that's not what would have happened. It would have been for something else. It would have been perhaps they'd gone over a certain limit, but it would not be from the Emergencies Act.
Great. Well, thank you. And that's why this discussion is so important, because sometimes in a political climate, these things get inflated and distorted. So I appreciate that answer. My last question then is, do you have information about these 180 accounts as to how many of those accounts were held by Canadian actors as opposed to actors outside the country?
I do not have that information.
Is that information you could obtain for the committee?
That's something I could take away.
Okay, thank you. Those are all my questions, Mr. Chair.
Okay, right on time. Thank you, MP Maloney. Thank you for joining us. We do have next is the block and MP Sainte-Marie for 2.5 minutes.
Thank you, Mr. Chair. Kim Manchester from the Manchester Society has affirmed that the banks are probably continuing to pursue the people who have been detected by the RCMP and that their name could end up in third-party databases in the private sector that the financial institutions use to fight against money laundering and the funding of terrorism. Do you agree with that affirmation from Mr. Manchester? And what are your comments on this?
Sorry, could you repeat the question?
Yes. I would like you to react to a statement that was made by Kim Manchester from the Manchester Society, who affirms that banks will probably continue to pursue people who've been detected by the RCMP and perhaps their names will end up in third-party private sector databases that financial institutions use to fight against money laundering and the funding of terrorism.
Oh, okay. That was similar to the question that was asked earlier, was what would be the impact of someone having been identified by the RCMP? And as I mentioned before, there would not be a blanket approach. Each organization would determine their risk assessment, as they always do, based on the specific individual. And if any individual had any concern about their banking relationship, they should contact their financial institution, but there would not be a blanket approach.
Okay, so certain institutions could maintain the names that have been transferred to them. There could be lists that might circulate, so these concerns might be well-founded. Is that the case?
Sorry, when I say there wouldn't be a blanket approach, what I'm saying is, a bank wouldn't all of a sudden generate a list and say, here are the lists that we received. no different than if you've learned of someone else who had conducted activity. They risk assess accounts as they do, and if they'd heard about that activity, they would assess each individual circumstance itself. It wouldn't be just, oh, we're going to list all these people here and treat a certain way. It would be done on a customer by customer basis.
OK, merci.
Okay, thank you. But that information will be conserved, will be kept, as you explained when answering Mr. Chambers' questioning. So thank you. That completes my questions.
Merci, MP Sainte-Marie. And we are moving to the NDP. MP Blakey for 2.5 minutes.
Thank you. So I think one of the important tasks of this committee is going to be to try to make some recommendations to government about, what it did that it perhaps ought not to have done, or how, if it does similar things in the future, it could do it better. So I'm just wondering, as you've said many times, banks are customer-based organizations. This clearly was something that had an impact on some customers. I'm wondering if you have any recommendations that you want to offer to the committee for its consideration about how, what kinds of supplementary direction government might provide, or what else it might seek to include in a similar order in order to have a better process in the event that something like this happens again.
Well, I would say, pretty much the clarity that we were getting in real time, having that from the get-go would be very helpful. First of all, to be able to assure our customers right away that the vast majority of them are not going to be impacted by this. So I would say, but similar to other things, that when you're used to a process, then you know what to expect. And so in this case, it would have been helpful to have had that in advance.
Okay. Anything else that you would put before the committee for its consideration?
Not at this time.
Thank you very much.
MP Blakey,
that's
okay?
That's good for me, Mr. Chair. Thank you.
Well, thank you very much. And we are moving to the Conservatives. And MP Chambers, you have the floor for 5 minutes.
Thank you very much, Mr. Chair. Just perhaps picking up off of my colleague, Mr. Blakey, in terms of, some of the information that you said would have been helpful clarity at the beginning. Are you talking about it before the order is announced, or just as you're leading up to this situation, that there was a little bit more back and forth between government and industry, or would you say that line of communication was open?
I would just say, obviously, we weren't able to ask specific questions until we saw the regulations themselves. And I give the government credit; they moved quickly, but it was still, very much in real time. Whereas, and again, I attribute it to the fact that this was an Emergencies Act, whereas the normal process, you'd have opportunity to do that before things were enforced. But I appreciate that was the context in which the act was invoked. But again, the question was in the context of, well, if you did this again, well, now we have learnings.
Okay, thank you. Do you think that there could have been more transparency, whether that's on behalf of the industry or government, in terms of how the powers were being used while they were being used?
In the sense of, you're talking about powers. So I just want to be clear, we had legal obligations, and for us, it was more of an understanding what the extent of those obligations were.
Okay, I'm thinking more in the context of transparency for the public. I think,
see. Okay.
You mentioned about, say, misinformation. I think one of the challenges that many of us had, and speaking as a legislator that was asked to decide or vote on whether the act was needed, there was not a lot of transparency in terms of how these extraordinary powers were being used both by government and by industry. And I would submit one of the reasons you saw some potential misinformation was because there wasn't a lot of transparency in terms of how many accounts would be affected, or the thresholds that were being used. So, do you think that more transparency would be helpful in the future?
Sure. I can say that we as an industry went out with media messaging. We had reactive messaging in place for all our customers. And at a certain point, finance had made comments about clarifying the very, very targeted scope.
Yeah, okay, thank you. I also, on procedural fairness, we talked a lot about notification and maybe the process through which, normally this might happen in terms of having a court order and an opportunity for, someone whose regular job is to evaluate evidence. I know that banks do a lot of good work on the money laundering side, but not sure you're the most well equipped to deal with, regular weighing of evidence and, determinations on whether sanctions, restrictions or banks' accounts should be frozen. Are there gaps currently in industry that are now will look to be filled in terms of getting more information or capabilities on this side of the house?
I don't see it so much as gaps being filled. I think the difference is because this was mandated versus allowing organizations the discretion to decide when something should or should not be reported, for example, to engage law enforcement, what have you. I think it's because it was mandated that's what presented the challenge.
Okay, thank you. And just perhaps a final point on procedural fairness. I hope you can understand and others can understand that, the reason why we care about procedural fairness is because, it's not so much that, you might look back now and say, well, everything seemed to go, okay, it was targeted, et cetera. But we have these procedural fairness requirements in the charter and other places in criminal law so that there is no abuse, in the future, even though there could be. So it's important for us to understand what some of those gaps might be so we can fill those in the future. So certainly appreciate your answers today. And I would say to other witnesses and to perhaps members of the government listening, I've really appreciated your concise answers here at this committee. It's made our job a lot easier, and I would hope that other witnesses review your testimony in terms of how clear and concise you can be. Thank you very much.
Thank you.
Yeah, and thank you, MP Chambers. Members, we have the Liberals up for 5 minutes, and MP McDonald will be the last questioner. And so, MP McDonald, you have the floor for 5 minutes.
Thank you, Chair. Just, maybe 2 or 3 rapid questions, but I think your testimony here today really serves a very distinguished purpose and relevancy to what the public were asking. And I echo Mr. Chambers' comments. I thought they were very well said. We all appreciate your time and your effort and everything that you've done. And we hope we don't always have to have you back. I'm assuming once the review is done, which is mandated through the legislation, that we do end up strengthening and reviewing all aspects of this process and protocol that happened. And obviously, this enforcement played a very significant role in ending this blockade. And we're seeing those restrictions and sanctions across the board now internationally, and they're playing an integral part. So our financial institutions are going to come to the forefront when you look at Bitcoin and cryptocurrency and how things are being non-regulated at some point. So I want to ask you, I know someone mentioned FinTrack a couple times, and I just want to know if FinTrack had notified you of any irregular transfers coming from abroad during the time that the act was invoked.
No, it would work the other way around. What we would do is we provide intelligence to FinTrack. So if there were any, first of all, as I mentioned, there's threshold reporting. So any sort of international transactions over the 24-hour 10,000 threshold would be reported into FinTrack, or any unusual activity we would report into FinTrack. They, as a central repository for that level of intelligence, would then make connections and conduct disclosures to law enforcement.
And Chair, I don't have any more questions. I think we've very significantly covered most questions, maybe even 2 or 3 times. But I would appreciate if Ms. Mason could even just give us a quick overview of going forward on her personal or professional opinion on how we can make things better overall if we have to go through this again.
Great. I would say that, basically what we've covered off, which is understanding the scope, limited nature. Again, we were told it was going to be temporary and very targeted. So we worked within that. But I think on proper assessment about the Emergency Act itself and how it would be invoked, I think it's really not our position to comment on that, and that should, be covered by the review itself.
Okay, thank you. Thank you for your time.
Thank you.
Okay, well, thank you, MP McDonald. And, I just want to say kudos to our witnesses, the Canadian Bankers Association, Ms. Mason, Mr. Hanna. I think you heard from MP Chambers, MP McDonald, but the sentiment, I believe, is from all members for the many questions that you answered here today in a very clear, concise way that will help inform our committee and this report on the invocation of the Emergency Measures Act. So we thank you so much on behalf again of the members, the clerk, the staff, the interpreters, everybody that is involved with allowing this committee to function. We thank you very much.
Thank you for having us.
Thank you.
Thank you.
Thank you.
And on that note, members, we are going to suspend for 5 minutes as we transition to our second set of witnesses. We are into our second panel members, and the witnesses with us today, the Royal Canadian Mounted Police. We have Michelle Arcand, Assistant Commissioner of Federal Policing Criminal Operations, and I believe it's Superintendent Denis Boudoin, Director of Financial Crime with us. And with that, I will allow them the floor for their opening statement.
Thank you, Chair. So good afternoon, Mr. Chair and honorable members of the committee. I am Assistant Commissioner Michel Arcand, responsible for the national picture of ongoing high priority federal policing criminal investigations, including financial crime. Joining me, as it was mentioned, I have the Superintendent Denis Boudoin. I am here today to discuss the RCMP federal policing programs use of the Emergency Economic Measure Order. I can say that from the program's perspective, the measures available to law enforcement under the Emergency Act and Order were welcome. Under this order, law enforcement and monitoring agencies were able to work more closely with Canadian financial institutions and use of financial measures to strongly encourage individuals to leave the illegal protests and deter the counseling of others to commit related criminal offenses. This order gives financial institutions the ability to freeze financial product of individuals and companies suspected of involvement in prohibited activities during the public emergency, and for law enforcement to share information with financial institutions for that purpose. Additionally, the order broadened the scope of Canada anti-money laundering, anti-tourist financing rules to include crowdfunding platforms and payment service provider, including virtual currency. With the order in effect, the RCMP worked closely with municipal and provincial partners to collect relevant information with regards to persons, vehicles, and companies directly or indirectly involved in the prohibited and illegal activities relating to the blockades, in particular the owners and drivers of vehicles who did not want to leave downtown Ottawa. The RCMP federal policing program leveraged real-time policing techniques from the Ontario Provincial Police and the Ottawa Police Service to validate and corroborate the presence of individuals in the illegal protests, and then acted as the central point of contact between police, derived information, and the financial institution. Through the receipt of this information, along with other information at law enforcement disposal, financial institutions could then assess whether or not to take action. During the 8 days when the Emergency Economic Measure Order was in place, from February 15 to 2022 and February 23rd, 2022, the RCMP disclosed information on numerous entities to the banks, the Canadian Banks Association, the Investment Industry Regulatory Organization of Canada, the Canadian Securities Administration, Credit Union, and the Mutual Funds Dealer Association. It is the RCMP understanding that at least 257 accounts were frozen by the financial institution, and the RCMP disclosed information on 57 entities to financial institution and other listed entities. Additionally, the RCMP identified and disclosed 170 Bitcoin wallet addresses and receiving funds linked to on-hold crowdfunding campaign, which raised 20.7 Bitcoin, which is a value between 1 to 1.2 million Canadian currency, during the period when the Emergency Act was in force. Many of these cryptocurrency wallet addresses were disclosed to virtual currency money service businesses via a series of cryptocurrency alerts. Noting that these e-wallets were linked to a joint RCMP and Ontario Provincial Police investigation, and directing these businesses to cease the facilitation of any transaction and to disclose any transaction information linked to the RCMP. The RCMP was also very clear to communicate that the measures under the order were not retroactive and to apply them only during the time that the order was in effect. Finally, it is important to note that the emergency economic measures order does not contain any enforcement provision. Therefore, no charges were laid by the RCMP under this order. As the power of the order, the RCMP was in constant communication with financial institutions to ensure that they were provided with the most up-to-date information possible on the status of entities of interest, so the financial institution could make the most informed determination possible before taking action to freeze or unfreeze financial products within their holding. The RCMP continues to instruct anyone inquiring about the process of unfreezing assets to contact their financial institution as the authority for this action rests with them. To conclude, these measures enhance the effectiveness of law enforcement's investigation pertaining to the blockade and help contribute to a peaceful and timely end to the public emergency. Thank you for your attention, and I will be happy to take any questions from you that you may have.
Well, merci, Assistant Commissioner Khan. We are moving now to questions, and that will be our first round. In our first round, each party will have up to 6 minutes to ask questions of our witnesses. And we have first up the Conservatives, MP Chambers. You have the floor for 6 minutes.
Thank you very much, Mr. Chair, and welcome to our witnesses. Thank you for sharing some of your time with us this afternoon. We just had some testimony from the Canadian Bankers Association, so some of our questions will relate there. I don't know if you had a chance to hear some of that testimony, but we'll get started. Can you just outline for the committee, in circumstances where the Emergencies Act has not been used in the past, so just thinking of the regular process, if you will, what process is used to have an individual's bank account frozen?
Yes, I will let Superintendent Denis Baudouin answer the question here.
Good afternoon. So normally you would have to bring an application to the court to have somebody's asset frozen or seized.
Okay, thank you. And is the reason why the Emergencies Act was so necessary in this case, with respect to clients of the financial institutions, is it a timing issue, why we weren't able to go to court? What was the necessity of the act for this circumstance?
Well, the necessity of the act on this one was service the law enforcement to be able to discourage people to maintain their involvement to the process and into the legal protest. And actually, given also the power to the banks to freeze accounts, because the RCMP didn't have the power to freeze the accounts. It was the bank that freezed the accounts. So it gave us more power to discourage people to be active into illegal protests.
Right, but presumably you could have went to court as in the normal course and had individuals, presented evidence, had individuals' accounts frozen through that means, correct?
Yeah, the difference, as Assistant Commissioner Arcan mentioned, is that the normal process you would have the asset seized for a long period of time related to an ongoing case. In this case, there was no provision to long-term seizure of assets. It was during the time of the economic measures, and the assets would be unfrozen after. So the process are quite different.
Okay. I mean, but we are setting aside some of our regular procedural fairness in the sense that, you know, a court did not make the determination whether assets should be frozen. We had private sector entities making adjudications and weighing evidence. Correct?
Yeah, that's correct. The financial institution had the onus to freeze or unfreeze assets.
Okay, thank you. And can you just describe at a high level what some of the information might have looked like or been from the RCMP to the banks? Was it a list of individuals for banks to review their own files with? Was it, you know, files on each individual in particular? What kinds of information was exchanged from the RCMP to financial institutions?
So we, as mentioned earlier, we work closely with the Ontario Provincial Police. Can you hear me now?
Yes.
Okay, sorry. So the RCMP worked closely with the Ontario Provincial Police and the Ottawa Police Service. So through the time, intelligence was gathered, and the RCMP, when the measure was applied, we did offer that the RCMP will be the center point to contact and share the information with the banks or the financial institution. So intelligence were gathered by those law enforcement and some by us also. And this is where we provided entities to the financial institution based on the information received from Ontario Provincial Police and Ottawa Police at the same time.
Okay. And we know of at least one case where the Ontario government, the Attorney General, actually sought a court order for an injunction to freeze assets. Was that process considered at the federal level with the RCMP?
So yeah, we were aware that some assets were frozen, but again, the assets were not frozen by the RCMP. It was up to the banks. So we volunteered information to the banks to make determination, and it could have been a possibility that assets would have been frozen under two orders, and even more so as civil orders were obtained later on.
Okay, thank you. And do you feel that there would be less misinformation or would have been less misinformation if there was more transparency at the front end in terms of thresholds and applications of scope of the order? There was some considerable concern and or misinformation circulating about scope.
The scope of law enforcement was really to the people, entities that influence the protests that were very active, and we limited there where we could ask the bank to freeze some accounts so we could discourage the people that are influencing the protests, and also truck drivers or companies that were not moving out of downtown. So it was not a large approach on this, where we really focus on individuals that were influencing.
Thank you very much. I believe that's my time.
Thank you, MP Chambers. We're moving to the Liberals and MP Zarowitz for 6 minutes.
Thank you so much, Mr. Chair, and I want to thank Assistant Commissioner Arcand and Superintendent Dennis Baudouin for being here today. This is a very important study for us. If I understand correctly, just because you always want to understand what did the Emergencies Act allow the RCMP to do that they weren't able to do before. And my understanding is that you were able, while you could have gone for a court order before, the Emergencies Act actually allowed the RCMP to actually act much more quickly and also be more temporary or limited, time limited in terms of actually freezing the accounts. Did I understand that correctly?
Yes, you're right.
Thank you. And how important was it to remove the ability to access the funds to ending the occupation in Ottawa and to preventing future blockades?
Well, we have to understand that when we started enforcing or sharing the information with the banks, it was unknown how blockades would end. So it was beneficial to put this in place to ensure that the blockades would conclude peacefully as possible. And then if there was any violence, then they would be limited so that people wouldn't have access to additional funds or to facilitate the criminal offense.
And just so I can draw that out a little bit more, so while there was a certain number of blockades that had ended, was there concern on behalf of the RCMP that there could be some additional blockades?
There was concern and there was monitoring across the country. If we look at the Ambassador Bridge, we look at Coutts, and we look at Emerson in Manitoba, Coutts in Alberta, we had to monitor if there was a risk to have more blockades eventually across the country.
Okay, thank you for that. Commissioner Leckie stated that the RCMP used the tools in the Emergencies Act not only to help disperse the blockades, but also as a preventative measure, which we're talking about now. But can you talk more specifically about how the financial powers under the Act were used as a deterrent to help prevent future blockades?
When we provided the entities to the financial institution, and the institution started to freeze accounts, we did reach out to some entities to see if they have left the area, for example, Ottawa. And some comments that we receive is, we're not going to go back. We're back home. Please unfreeze our accounts. And just to do this, it discouraged people to come back because they didn't want their accounts frozen. And actually, some people left being afraid that their accounts were going to be frozen.
So if I understood correctly, just the knowing that their accounts might be frozen sort of encourage people to go home and also encourage people to stay home and not come back, those who might have participated initially in any of the blockades. Did I understand that correctly?
Yes.
Thank you. And can I just so I can connect the dots for people in my riding and other Canadians who might be listening, a lot of the money came in through your crowdfunding platforms, and we're talking about freezing accounts. I'm assuming, and please correct me if I'm wrong, that the way that people would those who are part of the occupation or part of the blockades were able to access some of these funds is it was transferred from the crowdfunding platform where they collected the money into a bank account. Do I have that? Do I understand that correctly?
I think you're like the focus of enforcing these emergency measures were strictly to block the funds of people that were identified. The larger investigation as to where the money came from and how it was distributed, I think it's outside of the scope of the emergency measures. It's more in line with the overall criminal investigation.
Okay, so if I understood you correctly, you're kind of saying the crowdfunding platforms collected the money, but where the RCMP was able to play or do something is once it got into an account, when there was money into an account that could be attributed to the Ottawa occupation or the blockades, that's where the RCMP was able to collect the data and then distribute that to financial institutions.
I think it's important to understand that the focus of the RCMP, the intelligence came from the trucks and the people that were present in Ottawa. It wasn't the focus to start with donors or anybody that have received money. The point of using these tools were to make sure that people left the downtown Ottawa as peacefully as possible. So we concentrated our effort in identifying who was present in the downtown area. And then this is the information that we ended up sharing with the financial institution.
Okay. And then maybe my last question is, I know that there were certain gaps in terms of what the Proceeds of Crime and Terrorist Financing Act could actually cover in terms of activities. Can you give us an idea about what did the Proceeds of Crime, Terrorism Financing Act allow for, and what gaps did the invocation of the Emergency Act address?
In a short answer, please.
Short answer, it allowed it made crowdfunding platforms the obligations to report any payments to FinTrack, which were not covered before.
Thank you.
Okay, thank you. Thank you, MP Zerowitz. We are moving to the block, and MP Saint-Marie for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair, Mr. Arcon, and Mr. Baudouin. Thank you very much for being here in the committee this afternoon. I'd also like to thank you and your colleagues in the RCMP and the other police corps for the operations that you have carried out. Things went quite peacefully and orderly. That was quite impressive. As MPs, we were transported to the Parliament in your vehicles by your own members, and we'll be able to follow from the inside all of the operations, and we saw that most of the trucks left of their own accord. And I've seen other protests in the past, and I can say that all of this came to a very peaceful end. So thank you very much, and I take my hat off to you for that. I would like to know something. When the government decided to invoke the Emergencies Act and the 3 accompanying orders, how did that happen for you? Did the government consult with you? Was it the RCMP that asked the government to use this act? Or did you advise the government about certain elements that needed to be included in the act or the orders? Yes, there were consultations, and we issued recommendations on certain points during these consultations. But in terms of the Act, it's not the RCMP that asked for this or does this. We enact it. Once there was invocation of the measures in the Act, the RCMP then enforced these measures that were laid out in that Act and orders. In terms of the consultations for the financial measures, was it the RCMP that suggested to the government that one way of influencing the protesters and incite them to leave would be to actually freeze their bank accounts? No. Our answer is no. Thank you very much. And how did it work on a daily basis when it comes to the relationship between the RCMP and the government? Was it each minister that contacted you or each department, or was it a government representative that brought together the elements from the different departments and then communicated with you? How did communications flow between the RCMP and the government on a daily basis to cover all of these different aspects? There were conversations with the government at different levels, at the level of the commissioner and also at my level, and based on several government programs. Thank you. And then when it comes to the financial institutions, does the RCMP normally collaborate with financial institutions and entities? And how did it happen here? We've heard that there was a list of names that the RCMP provided to banks and financial institutions. So how did this actually unfold? The RCMP has regular contacts with banks and financial institutions, and with the emergency measures, of course, that stepped up the relationship with financial institutions and banks and the police forces. And when the emergency measures were enacted, we turned together with the Ontario Provincial Police and Ottawa Police Service, and we said that we could be the central point as the RCMP together with the financial institutions. So we transferred the information to the financial entities and banks, drawing on the information from the Ontario Provincial Police and the Ottawa Police Services and our own intelligence from the RCMP. Thank you. Now, when the Finance Department team came before the committee, we heard that the Finance Department had not given written guidance to the banks as to how they should proceed with the accounts, namely what should happen with a joint account or with an account where there would be child support payment to the ex-spouse to support children and so on. So could you tell us whether the RCMP was involved vis-a-vis the financial institutions or the government when it came to hammering out the details and verbal communications that were transferred to financial institutions to talk about the details of freezing the accounts and how to proceed. No, we did not have any discussions on the methods to be used by banks to freeze and unfreeze the accounts in question. We had discussions about the way in which we would transfer this information to the banks. The banks had the responsibility, the duty to put this into practice. In terms of discussions between the Finance Department and the financial institutions, we do not have knowledge of that level of communication. Yes, so I understand that if there were questions, it was between the financial institutions and the Department of Finance. It didn't go through you in the RCMP. Then a more general question. We know there's the aspect of financial crime, which is really evolving. It's moving and evolving a great deal. Do you think the RCMP is sufficiently funded and well equipped to be able to pursue this fight against all the different types of financial crime that we're currently observing? The RCMP is working very closely with the private sector and other law enforcement agencies as well. This regime helps us to make progress. Are we underfunded? Do we not have enough resources? Well, in general, there's a resource issue out there, and that's quite obvious. But we use what we have. We use all of the means available to us to fight against organised crime. When it comes to money laundering or other crimes, we work with FINTRAC very closely and other entities in the sector. Now, I see the chairman would like to cut me off. He doesn't like me to stray into these subjects, and that was a joke.
The questions you want to ask, you ask. But merci, MP Samari. We are moving to the MP and MP Blakey for 6 minutes.
Thank you very much. I just want to go over this ground again. It's been said that, these leaked list of donors were not part of the information that was passed on by the RCMP to financial institutions. So how did the RCMP develop the list that they forwarded on to financial institutions? Would that have been RCMP members on the ground taking license plates and deriving the identity of the owner of the car that way? Were they card checking people on the street in Ottawa? How did they identify the individuals that ended up on the list of names that the RCMP communicated to financial institutions?
So we did share information received from Ottawa Police and Ontario Police that was gathered. Initially, there was 15 entities that was provided to us from the collection of information by those services. The next phase was actually looking at the trucks or vehicles that didn't want to leave and blocking the downtown area of Ottawa and into the legal process. So we gather information based on license plate, name of companies, and drivers at the same time.
Okay, and then I'm curious to know, because we've also heard that once people left that it only would have been people who were in the area whose names were passed on. Does that only names of people who were thought to be in Ottawa were passed on, or were there names that were passed on from some of the from the border blockades as well?
We only look into the use of the measure order in Ottawa. It is possible somebody from BC was located in Ottawa, but we look at Ottawa only.
Okay. It's also been said that so once people left the area in Ottawa, that then their accounts could be unfrozen. Was that, what did that process look like? So was that a kind of, individual-led process? They got out of the area and then they said, I got to let somebody know I want my account unfrozen. I'm going to call the RCMP or I'm going to call my financial institution. Did the RCMP proactively provide information to financial institutions if the RCMP was sort of independently satisfied that the person had left? What was the verification procedure for unfreezing accounts, confirming that people were no longer in the area in Ottawa?
Some was, as you just mentioned, clients will go to the bank institution to prove that they left the area. Some of the information that we have that person left the area. And you need to realize, even though the blockade was taken down in a few days, the region, the downtown was very volatile. So we needed to make sure that the risk was not present. And also we took the initiative to reach out to some entities to find out and have a discussion with them. And from there, we identify which one and which entities were not designated and providing information to the institution for them to take action if they wanted to.
One of the things we've heard is that in the case where people's accounts were frozen under the authority of the Emergencies Act, it was up to the financial institution that they bank with to decide whether to notify them that their account had been frozen under the authority of the Emergencies Act or not. Do you think it would have helped or enhanced the deterrent effect of the account freezes to ensure that people were notified that their account was frozen as a direct result of the authorities granted under the Emergencies Act?
It's hard to really establish, if it would have helped or not. But what I can say is that proactively, before providing information to the banks, the RCMP also contacted a number of people to ask them where they were, and a lot of them would answer that they were in the blockades. They were not leaving, for example, and then we would tell them at that point if they were aware of the emergency measures. So, on top of the situation being very public, we took actions to call people also ahead of time before it was provided to the financial institution.
And so would you say that everyone who was on the list that you shared with financial institutions, the RCMP had at least made an effort to contact prior to handing over the name?
We have to understand, as Assistant Commissioner Arcan said, 15 entities were provided by the Ontario Provincial Police and the Ottawa Police Service. Of the rest that the RCMP provided, I want to say that the vast majority of them an attempt would have been made to contact them to ascertain where they were at before it was provided.
Okay, and in the cases where those attempts were not made, was that because the person met a certain criteria, or would that be what we might call colloquially falling through the cracks because the names came from other organizations outside the RCMP?
So some people may not have been contacted because the evidence was overwhelming that they were participating in designated offense. So it would have been a case-by-case basis based on all the information that could be gathered. You have to understand that a lot of information was available publicly also to the banks and law enforcement. So it's the totality of the information that would have been taken into account.
Thank you.
Case, thank you, Mr. Chair.
Thank you. Yeah, I know time goes fast, but that does end our first round. We are moving into the second round, members. And we have the Conservatives up, MP Lawrence, for 5 minutes.
Thank you very much. And thank you for your service to our country. It's greatly appreciated. I'm just hoping you can clear up a little bit of confusion I have. So my understanding, first of all, just to establish the facts, is that you were very specific in the way that you used the Emergency Measures Act. And you only people who were actively involved in those protests had their bank accounts frozen. Is that correct?
Yes.
Thank you for that. And thank you for brevity as well. But when we look at the order, it says an individual or entity that is engaged in directly or indirectly. So it is broad enough, and professors and other people have commented that's certainly enough that you could have provided information. In fact, bank accounts could have been frozen just based on that area. Why do you think? But for your work, you didn't need the provision to be nearly that broad. Am I correct in that?
Well, we enforced the law as it was passed, but we certainly put a finer comb to it because, as I said earlier, the sole purpose of using these methods was to clear the downtown area as peacefully as possible.
Yeah. Thank you for that. But it says directly or indirectly. Indirectly gets to the financial contribution, but you didn't use that. You had to have direct involvement in there. And I'm just wondering, because I understand the general deterrence, but when the justice minister goes out on TV and says that a financial contribution, granted a large one, could result in your bank account being frozen, or you should be worried anyways. But that wasn't what the RCMP was doing, correct? You guys were, unless you were involved directly in the protest, you were not giving information to the bank account. So I'm just confused as to why the government would sort of spread this misinformation.
I can't comment on other people what they've said. The only thing we can offer is the way the RCMP use the act, and we have like in any piece of legislation, we have some we take decisions sometimes, and in this case, we took the decisions to clear the protest as peacefully as possible. For example, we didn't provide information to insurance providers because we really wanted to make sure that the trucks would leave on their own.
Thanks very much. But and I appreciate that. But for the purposes of drafting the act, if this ever came into ever had and hopefully never will. You did not need that broad of scope. You could have had a much narrower, we just said directly as opposed to indirectly. And that could have reassured quite a few Canadians who thought that their bank account might get frozen, as the Justice Minister said, just simply based on a financial contribution.
So for Ottawa, it was more used directly. But if we have other places that would have protests, we could have used indirectly. It is possible.
But you didn't, is that correct?
For Ottawa, we didn't.
Okay. FinTrack was before our committee, and they had some interesting testimony where they said that the flows of the money into crowdfunding and into the protest, that they did not see any evidence of terrorist activity. Did you see any evidence of terrorist activity in the funding of these illegal protests and blockades?
I have not.
Okay, thank you for that. And then I understand that there was an argument for general deterrence, but specific deterrence. I understand that the specter of having your bank account frozen may have held people off from coming here. But did you, even after the bank account started getting frozen, this was released, I did not see the trucks leave until your officers did their great work and they cleared the protesters. I did not see people get in their trucks and drive away when the bank accounts were frozen. Am I missing something, or were there cases or material cases of people saying, oh, my bank account's frozen, I'm getting my truck and I'm driving home?
So as I said, we contacted people before providing information to financial institution. During this time, a lot of people wanted to leave, but were not in a position to leave because the streets were not cleared. What it did to us is that we would instruct these people to be ready, to make sure that their trucks would be ready to leave when the streets would be cleared, and it provide a picture as to the situation in different streets in Ottawa. And that information was passed on to the command center in charge of freeing the streets.
Thank you for your testimony. I see my time is up.
Yep. Thank you, MP Lawrence. We are moving to the Liberals. MP Chattel for 5 minutes.
Merci beaucoup, Monsieur.
Thank you very much to Mr. Arcon, Mr. Baudouin for being here. And as Mr. Sainte-Marie has said, I'm very proud of the work that you have accomplished during this very difficult period for everyone. I just have one point. We've talked a great deal about procedures which we were able to activate much more quickly under the Emergencies Act. So if we'd had to bring all these individuals to court who were protesting in Ottawa or elsewhere in Canada, if we'd had to bring them to court to be able to freeze the funding of these illegal activities. Could you give us an estimate of the time that would have taken? Well, that's a very good point. It's difficult to talk about an exact time because each case is different. But we certainly could not have acted as quickly as we were able to do with the emergency measures. So perhaps we would still be in the middle of protests here, there, and everywhere. So thank you very much for that answer. Now, earlier, we talked about trying to see and understand who benefited from all of this. And for me, this is a very important question. I'll give you some background to this. We know that certain U.S. groups and TV channels and U.S. politicians put forward propaganda, and they took some speaking points from Putin, and it's these same U.S. channels or U.S. politicians that actually publicly encourage donations to come in to support the illegal activities in Canada, including the convoy and the blockades that we witnessed. That really is a great cause for concern for me. And I'm joining dots because I've read two very serious economic studies, one from Cambridge, Massachusetts, and several economists have been assessing how much dark money has been received, and they have evaluated at $1 trillion. And a quarter of that would be associated and can be traced back to Putin himself. So my question is, if, for example, someone in the entourage of Putin decided directly or indirectly to fund extreme right groups and fund a platform and donate $1 million in a platform to fund group activities in Canada to overthrow a democratically elected Canadian government. Today, with the financial crime laws that you have, how would you be able to find that sort of information? The changes that have been made within FinTrack so that crowdfunding platform sites would be included would certainly play a role then, so that FinTrack would be able to identify these payments or these transfers and then be able to alert the competent authorities. So today, if that were to happen, we wouldn't be aware of this? Yes, because the crowdfunding sites are now included. But that's under the Emergencies Act, says the MP, and not under the Financial Crimes Act. So the crowdfunding platforms, as we say in English, were covered under the Emergencies Act, but they're not captured under the Proceeds of Crime and Terrorist Financing Act. Well, my understanding is that the changes have been rendered permanent on that aspect. So that's a good legislative change to capture these crowdfunding platforms. Last year, we had made a change to include cryptocurrencies. That's now captured. And under the Emergencies Act, there's also the service providers. I was looking for the translation in French. So you think it would be good to cover these service providers on a permanent basis as well? Yes, absolutely. Financial crime is constantly evolving, and cryptocurrencies are playing a role, so we have to adapt to what's happening, for example, with crowdfunding. That all plays a role here. So I think it's important to adjust to all of this so that FinTrack can receive the necessary information on these platforms in real time and then inform the police forces accordingly. So first of all, we have to extend. Thank you, Mr. Chair.
Thank you, merci, MP Chat.
Thank you, MP Chat.
To the block, and MP Sainte-Marie for 2.5 minutes.
Thank you, Mr. Chair. I'll continue on this question of crypto assets. Earlier, you recalled that there was equivalent of $1 million that came in terms of bitcoins to support the protesters. Were you the ones who followed the funding amounts for the occupation in Ottawa? And if so, in terms of crypto assets, did they mainly originate from Canada or from foreign countries? I do not have that information with me. Certain employees did look at the origin of the funds, but I don't have that information with me today to share with you. Now, if it would be possible to send in that information to us, that would, of course, be very much appreciated. And still on crypto assets, what was the biggest challenge for you in terms of fighting against financial crime and to monitor crypto assets? Is it much more difficult than traditional money? Well, just to give you an example, I believe there's 17,000 different types of cryptocurrencies, and you can, in fact, create your own cryptocurrency within a few minutes. Often we hear about bitcoins and the more popular ones, but the system is constantly changing, and we have to adapt accordingly. It's so easy to create a new crypto currency, and so that poses certain challenges in terms of law enforcement. Thank you. And for crypto assets that are already well established and that are well known within your services, such as bitcoins, is it more difficult to monitor what's happening with those transactions compared to traditional money transactions? I would say yes, but there are tools that are available, publicly available tools for tracing these funds. These are available, and we are developing expertise to adapt accordingly and remain abreast of all of these developments. Thank you. As I just have 2.5 minutes for this round, the next round, I've got a bigger subject to come up on insurance, so you'll hear back from me again in about 20 minutes. Thank you.
Samavi, we have the NDP up next, and MP Blakey for 2.5 minutes.
Thank you. So we've talked about, the RCMP passing names on to financial institutions for the purposes of freezing accounts. We've heard a little bit about the process, such as it was for people to have their account unfrozen. In a case where somebody disputes that they were in the Ottawa area and therefore maintains that their account was improperly frozen according to the legislation, we've heard that they may not even have gotten a notification that their account was frozen under the authority of the Emergency Measures Act. How do they go about pursuing a remedy or trying to establish in a court, for instance, that they weren't there and that their account was frozen because law enforcement believed that they were?
Well, we were in constant communication with the banks and the financial institution during this at that point, and we wanted to have open communication. And if that would have been the case, somebody would have called the banks and been able to prove to them that they were no longer or not involved in criminal activities. And we certainly offered to be contacted by the banks to either affirm this or provide any information as necessary.
Okay, and not to belabor the point too much, but I think it's important for people to know if they feel that they were wrongly targeted because they weren't in the area. I'm just trying to figure out what the process would look like for them, not only to have their account unfrozen, because I think are there any extant frozen accounts out of the use of the Emergencies Act? I have to believe that there aren't, because the emergency period has come to an end. I'm wondering what documentation people have in order to be able to
say my account was frozen because someone believed that I was in the Ottawa area during that time. I was not in the area during that time. And so my account was improperly frozen. And if they're seeking some kind of remedy or redress for that, on what basis would they do that? What kind of documentation would they have? A phone call is one thing. They call the bank. They say, I never was in the Ottawa area, unfreeze my account. The bank talks to you guys. The account's unfrozen. But in the event that there was some kind of timely transaction that they weren't able to make because their account was frozen and they want to seek a remedy, what kind of documentation can they expect to get to help them in their effort to pursue that question with the courts?
With a short answer, please.
I think the best way will be to communicate with their institution. And from there, the institution will probably come back to us and we'll have a discussion.
Thank you. And thank you, MP Blakey. We're moving to the Conservatives. We have MP Fast up for 5 minutes.
Well, thank you very much. And I want to echo the congratulations to both of you and the RCMP for the role you played in effectively, peacefully bringing an end to the protest. Mr. Arcand, I understand you testified that the freezing of accounts under the Emergencies Act was intended to encourage the influencers and the leaders of the protest to stand down. So how many of the key leaders and influencers of the protest actually did stand down as a result of the banks freezing their accounts or the threat of their accounts being frozen?
To answer directly your question, I don't have the specific numbers. The initial numbers that was provided to the banks on entities that we know that they were influencers and that came directly from the Ontario Provincial Police and Ottawa Police was approximately 14, 15. So to tell you how many that left, I don't have those numbers.
Could I have you provide the committee with that information? Because it is critical, because it goes to the very efficacy of the powers that were exercised under the Emergencies Act. We want to know, did the Emergencies Act actually achieve what it was intended to do, which was to get the influencers and the leaders to back down? Is it also your evidence that those freezing powers could only have been exercised by triggering the Emergencies Act?
The way to have the bank freeze the account? Yes.
So there's no method outside of the Emergencies Act, a legal method, under which you could gain the power to have accounts frozen. Is that right?
Yeah, one thing that we couldn't do is share information with the banks. And really, that's the only thing the police gain from the act is to be able to share information with the financial institution. And there's no provision in place so clear right now.
But there is a provision for the RCMP to freeze accounts by getting a court order, correct?
Yes, but in this case, it wasn't the RCMP that was applying to seize the assets, like in normal cases. The RCMP was given, or police services were given, the power to share information.
All right. Over the 3 weeks leading up to the triggering of the Emergencies Act, did the RCMP ever apply to the courts for powers to take down the blockade, for powers to freeze assets, discourage protesters? Was there any point in time during those 3 weeks when the RCMP actually availed themselves of existing policing and legal authorities to achieve a peaceful end to the protest?
Your question is directly to the role of the RCMP. So the protests in Ottawa, we weren't the lead agencies on this. It was the Ottawa Police Service and Ontario Police Service.
Did the federal government ever ask you to take the lead, as it did in the end when it came to freezing accounts and bringing an end to the protest?
For us, it was clear that there was Ottawa Police Service has the jurisdiction on what was going on downtown Ottawa.
And the RCMP had no involvement at all with the federal government in providing advice and opportunities?
We're providing advice and support, but the lead was still the police of jurisdiction.
Did you ever ask the federal government to avail itself of existing legal and police authorities to bring an end to the protest?
To my knowledge, no.
I'm sorry to hear that. It's unfortunate the Emergencies Act was even triggered in the first place. It was quite unnecessary in my mind. Just a couple of further questions, if I might, gentlemen, and I appreciate your candor. How did the RCMP actually identify individuals targeted by the Emergencies Economic Measures Order?
So there's two streams of people that were, or entities that was disclosed to financial institution. The first one, as we mentioned, came from the OPP and the OPS, and those would have been or were the the suspects in their investigation. And then the second stream was came from plate numbers of trucks and vehicles in the downtown area.
Thank you. Thank you, MP Fest. Yeah, we're over time. We are moving to, and get this right, the Liberals and MP McDonald for 5 minutes.
Thank you, Chair, and thank you to both gentlemen here today, and thank you for what you've done. There was a lot of stress, obviously, on downtown Ottawa and points of entry across the country, and disrupted daily lives, and obviously our Canadian economy. And it's scary to think going forward what could actually transpire. But I just, we've heard a lot of things about, people saying there was disinformation and, accusations and all kinds of information that necessarily wasn't available at the time. But is that not part of the process of going through this, is to ensure that your intelligence is withheld within the law enforcement community that are providing the services to eliminate basically the occupation in downtown Ottawa? Like, how much does that play? We're asking about some of the questions are basically deferring to, oh, why didn't you do this, or why didn't you say this publicly? But to me, would that not be part of the process, is to ensure that your intelligence is kept within, to ensure the protection of society and protection of your officers that were going to be in charge of this whole process?
Yes, exactly. And to add to this, the safety of the citizens of Ottawa also, that we need to make sure that everybody was safe and there was no violence to this.
And I was there for 2 straight weeks at my residence, and I was in the red zone. And I can tell you, watching you guys do your job when you started moving people out of the city was pretty amazing to watch, with no basic injuries and no retaliation to some extent, especially after what we've seen at Coots and what could have transpired in that regard. How beneficial was invoking the Emergency Act for law enforcement? And if you could just reach on a little bit of the jurisdictional, because that was a question at the time, why is not the OPP or Ottawa Police or the RCMP getting involved? How important was invoking that Emergency Act to ensure that there was a consistent process put in place to do your job?
Well, it did allow the RCMP to get involved with all the law enforcement partners. It did allow to use other tools than other tools that was already existing. It allowed the Ottawa Police to use those tools for the Ontario Police also and the RCMP to move or address the situation quicker.
Okay. And change pace here for a second, but FinTrack, what red flags? We've seen an infiltration from south of the border, mainly on funding into the convoy and through crowdfunding platforms and payment processing, etc. But like, at what point or are you notified by FINTRAC that there's red flags going off? Is there an amount, or is there some other avenue that you see or they see and they provide you with detailed information to raise that red flag?
So it comes through a variety of different means. It could be the amount that is not in line with what this entity should be doing. It could be the type of amount or the number of transactions that's happening. It could be the origin of the money. So FINTRAC is looking at this with their analysts, and then when they feel it's something that is needs to be disclosed to the police services, this is when they do so. But there's not just one specific things. They look at the totality of the evidence and information at their disposal.
Okay. How much time do I have, Chair, again?
You got about 30 seconds.
So a quick question. How long did it take, once the Emergency Act was put in place, how long did it take for the RCMP, the OPP, and the Ottawa Police and Parliament Security to actually come together and provide the service that you did to set up a plan of attack on removing people from downtown Ottawa?
I don't have the specific answer to this, okay, but as soon the act was there, we looked at it and how can we apply it, and okay, other tools also.
Thank you.
Okay, thank you, MP McDonald. Members, we are moving into our third round. This is our final round. Each round takes about 25 minutes, and we're starting with the Conservatives and MP Albus for 5 minutes.
Thank you, Mr. Chair, and I will be sharing my time with Member Fast. So first of all, gentlemen, thank you for your service to our great country and for being here today to lend your testimony. I have just a few quick questions. So the first question is something that's been asked to me by a constituent that noticed that there's a certain amount of common sense involved when you want people to cooperate. One individual had mentioned to me that it seems counterintuitive to say to someone, "We've frozen your accounts, so leave." Usually when you want to drive away or encourage people to leave, it requires money to do so. How do you respond to that?
Well, we felt that it was a good measure to put in place, and we can see it on a larger scale right now around the world. But, restricting financial assets of somebody certainly played a part in this.
But if you want someone to drive home, certainly they're going to need money to buy gas and to get a breakfast at Denny's on the way home.
Yeah, we were not expecting people to drive 2,000 kilometers right away. We're just expecting them to maybe drive 2 kilometers away from the unlawful protest.
Okay, well, anyway, thank you for the answer. Second question I had was just on how the order applied. So everyone seems to be fixated on Ottawa, and for good reason. But my understanding of reading the order, that anywhere where there could be a blockade of any kind on critical infrastructure, like a bridge, et cetera, these tools would then apply. Is that correct?
Yes, you're right.
So there was no geographic targeting, as the Prime Minister and his minister said. This is literally anywhere where there was a situation the government order could apply to. The RCMP could utilize those powers under the order.
Yes, they could. Any law enforcement could provide the information to a financial institution.
Whether or not the provincial police, for example, in Quebec, the Premier Legault had mentioned that he felt that it was not necessary to apply. Is that correct?
Yes.
Okay. All right. I'm going to pass my time on to Member Fast, please, Mr. Chair.
Mr. Marquand, I believe you also testified that that the Emergencies Act, including the right to freeze accounts, made it easier for you to remove the protest. Is that correct? I'm trying to remember what you said.
Yes, it did facilitate.
Facilitate. Is it your testimony that it made it easier for you to? Okay. Yes. Do you believe that it's the function of policing authorities to have their life made easier, or in the first place to conduct themselves and have the powers that reflect due process and the rule of law?
We apply the law that is offered to us that we could apply, that could work on our towards the achievement that we want to achieve.
So my fear is that it is the effort of the government to try to get the blockades removed in an easier fashion rather than in a fashion that was appropriate for the circumstances that drove their decision to trigger the Emergencies Act. And yes, you were given additional powers that I believe facilitated your ability to get this done, but your testimony is that there were no efforts made in the lead up to the triggering of the act that would have applied court orders to perhaps secure the kind of support that police authorities needed. So you can understand my concern. And that's why I asked the question. Was your concern that your job would be made easier, or was it your concern to comply with the rule of law and do it in a way that reflected Canadian standards and Canadian expectations?
We will offer another tool to apply to facilitate and address the situation. The same thing with the Ontario Police use the Ontario Act.
Yeah. Was that tool necessary? Actually,
it shows on the Economic Measure Act, it was necessary and it was useful.
All right. Thank you, Mr. Chair.
Thank you, MP Fast, MP Albus. We are moving now to the Liberals. I have MP Maloney up for 5 minutes.
Thank you, Madam Chair, or Mr. Chair, rather. And let me add my thanks to everybody else, to the RCMP and to all of the law enforcement community, because what you did in Ottawa was, all of us were there. We witnessed it. It was truly remarkable, and you did it safely. I'm going to pick up on something Mr. Fast was just addressing. My thinking was similar to his, but I come at it from a different perspective slightly. Would you agree with me that the function of the police is to make the community safe, sir?
It is the primary function.
Right. Because those of us who were in Ottawa witnessed a situation where 4,000 or 5,000 people were scared to leave their homes and couldn't go to work for a period of 3 weeks. So although I was less concerned about their ability to stop at Denny's in Kingston, I was more concerned about the people of Ottawa being able to remove themselves from their homes and go about their business. So you started, sir, your evidence today by saying that the Emergency Act measures were welcome, I believe. Could you explain in further detail what you meant by that, sir?
Again, is providing law enforcement other tools to address situations like this. And it permits that.
And you felt that you didn't have those tools at your disposal before the invocation of the Emergency Act, is that right?
Specifically to the economic measure orders, it was useful.
Okay, and am I correct then, sir, in saying that part of the reason you felt that way is because, as you said a moment ago, this was an Ottawa police operation, and until the invocation of the Emergency Measures Act, you didn't have the ability to work with all of the law enforcement agencies to resolve this situation peacefully. Is that fair?
It brought the RCMP into the portrait, yes.
Okay, thank you. Mr. Fast also talked about, I think he mentioned the fact that nobody had sought a court order prior to the invocation of the act. How long would it take? I mean, each of those 257 accounts that were frozen, if you were to do that by way of court order, each one would require an independent application before the court, correct?
You're right.
And each one of those could take days to run their course. Isn't that right?
Each case is different, but it could take a long time for the investigation to be built and bring the proper affidavit before the court, yes.
Right, and those applications would have been brought by the RCMP perhaps, but also perhaps the Ottawa Police Force or even perhaps the OPP. Is that correct?
Exactly.
Okay. And absent the Emergencies Act, you didn't have the ability to coordinate your efforts in that respect. Is that fair?
The portion of the bank's account, yes, you're right.
Okay. All right. Thank you. Now, am I right when you said 257 bank accounts were ultimately frozen? Or thereabouts?
Thereabouts,
okay.
227, 257.
So there were significantly more than 257 trucks in Ottawa. There was certainly significantly more than 257 different groups of people in Ottawa. So this wasn't a blanket shotgun approach to freezing bank accounts, was it, sir? You were doing this strategically in a way that you thought would be fair and help resolve the situation quickly. Is that a fair way of characterizing it?
Yes, you're right.
Okay, thank you. Now, are you familiar with, were the accounts that were frozen, by the way, entities from across the country, or were they all Ontario-based?
It was a mixture of people from Ontario and other places.
Okay, and those other places, I assume, overseas as well?
I don't know about overseas. That I know, it was mainly in Canada.
Okay, and my last question, sir, I believe you or your colleagues said that the information was gathered in several ways, one of which was walking the streets of Ottawa and looking at truck identification. We know that the province of Ontario introduced the Emergency Measures Act that they have at their disposal, which allowed them to suspend commercial licensing for certain vehicles. Were you part of the information gathering that was used by the province in that process?
No.
When I say you, the RCMP, no?
No.
Okay. Those are all my questions. Thank you, Mr. Chair.
Okay, merci, MP Maloney. We're moving to the block, and we have MP Sainte-Marie for 2.5 minutes.
Merci, Monsieur Fonseca.
Thank you, Mr. Fonseca. I'd like to talk about vehicle insurance. Under the order, it was possible to suspend automobile insurance. Would it have been possible for a trucker who had his insurance suspended to actually leave the occupation by road driving without being insured? Circulating with a vehicle on a road is only possible with insurance. That is why we did not use that part of the order. So you're saying that the part of suspending insurance was not used and no motor vehicle insurance was suspended. Is that the case? According to the Act, we did not use the Act, but the Ontario Provincial Police and Ottawa Police Service did suspend permits and insurance. And did the government consult you, or did you give your opinion about the suspension of motor vehicle insurance when the orders were being drafted? Not as far as I know is the answer. Thank you. And of course, when we read this, we were really astonished, and we were told as well that the rule was that you should wait a bit before you suspend insurance to allow the truckers to actually leave while they're still insured. But we also told, apparently, insurance companies that you can give it back to them once they've left Ottawa. So it seemed rather difficult to apply. And of course, there was this risk that perhaps a trucker could have caused an accident and the victims could not have been compensated. So I'm reassured to hear that that part of the order has not been applied, so it seems to not be useful. And that's what happens when we draft the things so quickly. So I'll leave my questioning there as time is running. Thank you.
Okay. Merci, MP
Thank you, MP Sainte-Marie.
NDP and MP Blakey for 2.5 minutes.
So understanding that these were temporary and limited powers, as you've said, really focused on clearing out downtown Ottawa of the illegal occupation. There were other concerns around financing that were raised in the course of this, including the provenance of some of the the donations being from outside the country, supporting some people who had, very clearly insurrectionist goals in terms of their own behavior and goals. So I'm wondering what the follow-up looks like to try and understand how that happened, how that worked, and what Canada needs to do going forward in order to be able to protect itself from foreign interference helping to generate this kind of illegal activity again.
Yeah, at this point, it is limited what we can share. There's an ongoing investigation, and we wouldn't want to compromise it.
Okay, but understood that the authorities of the Emergencies Act are not part of that effort. That's a separate effort and investigation. Those powers were really used in a time-limited and temporary way to clear downtown Ottawa of the illegal occupation.
That's correct, yes.
Okay, thank you very much. I'll just, I don't have a lot of time remaining, but I'll offer you the remaining time. If you have any recommendations for the committee to consider, of course, part of our role is to look at what happened in the use of the Emergencies Act and recommend any different ways of going about it in future, in addition to highlighting any potential abuse of those authorities. I'm just wondering if you have any recommendations for the committee to consider.
Yeah, maybe clarity on the, like in this case, like the measures were not implemented for a long period of time, but in the case that it would have been, once something is seized or frozen by the financial institution, what exactly is supposed to be happening? And like I said, we maintain communication with the banks on a daily basis, and a lot of questions we didn't have because we're not in the law. So we would refer the banks back to their general counsel at this point. But for example, seizing of shares of the company that fluctuates, things like this. What exactly are the banks supposed to do with this? And I think the clarity is more on the bank, and maybe the previous speaker pointed to that at the same time.
Okay. And are there any assets that were frozen that have not been returned to their owner?
Very quickly, please.
Not to our knowledge. Again, it's up to the banks, but.
Thank you. And thank you, MP Blakey. We're moving to the Conservatives. MP Chambers, you have the floor for 5 minutes.
Thank you very much, Mr. Chair. Appreciate the candor and comments so far. Is it the testimony here today that outside of the use of the Emergencies Act that the RCMP is unable to work with other levels of jurisdiction?
Well, each provinces have their own police act, and they could request for assistance, but they need to follow their process.
Okay, and did they not ask for the RCMP's assistance prior to the Emergencies Act?
We did provide some assistance.
Okay, just trying to understand how the Emergencies Act was necessary. I appreciate that you mentioned it acted as a deterrent. Would it also not be true to suggest that a deterrent would have also been to enforce the law on the individuals who are breaking the law prior to the invocation of the Emergencies Act? Like that would have acted as a deterrent as well had we been arresting some of the heads of this movement.
It's hard for me to comment on the process, how it was applied, and how police services, the Ottawa Police Service, apply the request and all this. But to come back to the Economic Measure Act, it had a deterrent.
Thank you. And perhaps, Mr. Baudouin, you mentioned earlier that the reason why a court order wasn't sought was sometimes those last for a lot longer than the Emergencies Act. So were we saying that the reason we had to use the Emergencies Act was because the regular process would have been too harsh a penalty?
No, I was just trying to differentiate between the two processes. And as I have also said earlier, the only thing that was gained for law enforcement was the ability to share. The process you're referring to is on application on law enforcement. In this case, law enforcement didn't apply to have something seized. We only shared information with the banks who would apply the seizure.
Okay, thank you. Some of my colleagues have mentioned how long it would have taken to go through the court, but I hope what we're not hearing today is that it would have been, we use the Emergencies Act because it would have been inconvenient to follow regular procedural fairness. I think we have to see some evidence that the Emergencies Act was absolutely necessary to be used in this case, or that there was no other avenues available through which we could have achieved the same outcome. I believe this has been very helpful in showing us some of the evidence before us. I would yield the rest of my time to MP Lawrence, Mr. Chair. Thank you.
MP Lawrence.
Perfect, and thank you for your testimony as we wrap up here. Just want to go into some of the specifics of the information that was shared. So when you identified someone that was directly or indirectly supporting these illegal activities, was a briefing document provided, or what did that document look like to the financial institutions?
So we did provide a document, and investigators would conduct a series of checks on public and police databases, and then they would provide the information that was gathered to the financial institution for them to make determination at that point.
And were there personal information in there? Like, was there other things that were not public? And specifically, was there location, their wealth, their gender, their race? Were these pieces of information included?
There was some information available to police database.
I want to be, I don't mean to be a stickler, but I asked some specific questions and I'd like an answer. Were any of the 4 or 5 characteristics that I identified included? And could you tell me which ones?
Yeah, so it would have depended what was available in the police database. And some of them, it could have been, the sex, the height, to previous police dealings, whether they were suspected in other crimes or witnesses in other crimes, or different types of dealing. So a lot of different information. So it's hard to enumerate every single one categories of information that was provided,
and this very private information would have been provided to 5, 10, 15 financial institutions, or just the one?
No, to the financial institutions.
So how many would that be?
It started with only the major banks, and then it later included the credit unions and other entities also.
So, sorry, Mr. Chair, I see.
Well, 5 minutes. I don't know if it was very short.
Yeah, I'll be real quick then. The point of it is that each one of these institutions would have had probably multiple people seeing this. So it could have easily been 50, 100 people that would have seen this very personal information to people.
Yes, the information was shared with the financial institutions.
Thank you.
Thank you. Thank you, MP Lawrence. And our final questioner, we've got the Liberals, MP Zerowitz, for 5 minutes.
Thank you so much, Mr. Chair. And I want to thank our 2 witnesses for their patience and for doing such a great job in terms of answering our questions. Listening to the testimony, I had to remind myself take myself back into the situation of how it all started. The trucker convoy, it coming towards Ottawa, it sort of moving from a protest to an occupation. And my sense is it's something that has never really occurred. It was highly unusual. And maybe I can ask any of our witnesses who want to sort of talk to this, what was unusual about the situation, from the start as it sort of unfolded? Could you comment on that?
Good question. Over 34 years, we have seen several protests, but as a siege like this, people don't want to leave, and taking control of a downtown area as a major city, that was the first time, really.
Thank you. I appreciate that because we have to almost remind ourselves of it, because it was not only the siege, but then the blockades. And then it was not one blockade, but it was multiple blockades across the country. Had you ever seen that before as well? Or is that the first time as well?
A movement like this in Canada, and now it's going globally? No.
Thank you. I appreciate that. And I just want to confirm again, as things progressed, you had mentioned, I believe, if I heard correctly, there was some consultations around some additional measures or powers that might be needed. And my understanding is the federal government had consulted with the RCMP, and the RCMP had indicated they needed some additional measures in order to urgently address a situation that was rapidly and aggressively and unpredictably unfolding. Can you just confirm that the recommendation was from the RCMP that additional Emergency Act measures were needed? And specifically the three that you had mentioned, the ability to more quickly ability to share the information with the financial institutions, very quickly be able to do so, and for a time-limited way.
There is some areas in the Act that served us, and for sure, it really served us as law enforcement. Just for the travel, for example, the Economic Measure Act, we were limited to what we had in front of us, and when this came to us as law enforcement, it was another tool to be used.
And also it seemed like, and I don't want to put words into your mouth, Assistant Commissioner, but it seemed like also things had progressed, and it got to a point where we needed some urgent tools to be able to aggressively deal with the situation. And so for me, that is what I'm hearing from today. And so the Emergency Act, was suggested in a time-limited way, in a geographically defined way, for us to be able to address the issue. There was some. I'm forgetting who asked this, but there was some comment about the local police sort of not like being the area of jurisdiction, and whether or not the RCMP should have advised our federal government. And again, I take it to the unusualness and the first time of this type of situation, when there's often what would be seen as a local situation on the ground, sort of in Ottawa. Is it typical that the RCMP would go to the federal government and provide advice? Or is there a tipping point, or is there sort of a normal protocol that's in place?
Well, there is on regular discussion having with government, not necessarily asking them to address the situation, but we could look at ways to address it.
Mm-hmm. And then now that this is in my final 30 seconds, what if now that we've enacted this Emergencies Act and now we've revoked it, and this is along the lines of Mr. Blakey, if you had to make some recommendations again, what have we learned that you might sort of add to if you were consulted again, would you have added something, or would you have left it exactly with what you would have recommended, or what you had recommended to our government around the Emergencies Act and the measures that you needed to bring things under control?
It's hard to pinpoint exactly where we could improve. One area was explained by Superintendent Denis Baudouin is surely to have more precision on how could we freeze accounts and how we're going to be acting on it if it was for a longer period. Probably more guidance for the financial institution. But to go back exactly on what area that we need to adjust, I think it will take some time and reflect on this and come back.
Thank you so much. And again, thanks to both of you for your excellent presentation today and for your patience in answering all our questions. Thank you.
Thank you, MP Zerowitz. Members, we've had two panels today, excellent witnesses, I would say. I think that's what all members have been invoking here and saying, and actually on the invocation of the Emergencies Measures Act. And and to inform our study. We want to thank Assistant Commissioner Michelle Alcon and Superintendent Denis Baudouin for their time, for their remarks, for their answers to many of the questions on behalf of the Standing Committee on Finance. Thank you, gentlemen, and thank you also on behalf of all those, the clerk, the interpreters, the staff, and all those that help with our committee. We thank you for your time. Thank you.
Thank you, Chair, and I really appreciate the comments that was offered to all the law enforcement that took place and involved in Ottawa. Thank you. I'll pass it on.
Well deserved. Thank you very much. Members, shall we adjourn?
Are you revoking the meeting?
Immediately.
Immediately, yes. Okay.
I second that. Thank you.
Take
Great
care.
evening. Bye.
Bye.